Hello friends, today we are going to discuss about psychotherapy documentation part 3. I am Dr. Suresh Badadmat, Professor of Psychiatry working at NIMANS Bangalore. In this video, I'll be discussing about psychotherapy documentation, what are the legal requirements, confidentiality, and tips for recording psychotherapy sessions. Let's discuss it. Documentation of psychotherapy. There are various important documents which need to be part of psychotherapy documentation. Although there are no hard and fast rule, these are important elements which I recommend for the therapist to keep. First and the foremost is referral letter. Second one is intake sessions, notes, consent form, detailed evaluation, skills or psychological assessments, session notes, also called as progress notes, case notes, psychotherapy notes, referral termination or dropout notes, finally, the formulation or summary notes. But however, these are all textbook description of keeping the documentation. However, there are legal requirements for documentation. They are considered as mandatory documentation if you are a psychotherapist or if you are doing psychotherapy. What are those mandatory documentation? Intake session notes, consent form, scales and psychological assessments, and session notes. These are the 4 ingredients which you should not miss when you are doing psychotherapy. They are part of the legal requirement of Mental Health Care Act of 2017. There are optional documentation based upon if you are an individual psychotherapist or part of a hospital or a teaching institution or a medical college. This can be added and kept, such as referral letter, detailed evaluation notes, psychotherapy notes to discuss with the supervisor, referral termination or dropout notes, finally the formulation and summary notes. However, if you want to have a good clinical practice, try to maintain all these records. Let me repeat. The mandatory documents are mandated under the law in India. They are part of Mental Health Care Act of 2017. Mental Health Care Act of 2017 came into force on 7th April 2017. Subsequently, various rules have been notified. As per the Act of Mental Health Care Act of 2017, Section 23 clearly talks about right to confidentiality. What does it say? Here, a person with mental illness has right to confidentiality. That means a person with mental illness shall have the right to confidentiality in respect of his mental health care treatment, and physical health care. However, there have been exceptions which have been placed. That means right to confidentiality is not absolute. Under certain circumstances, this confidentiality or privileged communication can be broken. This can be broken to nominated representatives, to other mental health professional if you are referring the patient, to protect any person from harm or violence, or only such information which is required to protect a person will be divulged. It will be divulged to the competent authorities or to the police. Release of information can be done upon the order of Mental Health Review Board, central authority or state authority, maybe Supreme Court or High Court, and the release of information should be in the interest of public. That is, my dear friend, right to confidentiality. At the same time, Section 25 talks about right to access for basic medical record under the Mental Health Care Act of 2017. What does it mean? All persons with mental illness shall have the right to access basic medical record as may be prescribed. Here now the question comes, what do you mean by basic medical record? Here, the mental health professional in charge of such records may withhold certain information before disclosing. If there is a serious harm which is going to occur for persons with mental illness or likelihood of harm to any other person, that records can be kept. However, whenever any information in the medical records is withheld from the person, the mental health professional shall inform the person with mental illness of his right to appeal or apply to the concerned board for complete disclosure. It is left to the mental health review board to take a decision whether the complete record has to be given or else just the basic medical record. However, now the question comes is whether the RTI Act overrules Mental Health Care Act of 2017. Here, since Mental Health Care Act of 2017 is very specific for persons with mental illness and their records, and here this Mental Health Care Act of 2017 has clearly written various other laws with regard to mental health care, this law prevails over that law. Hence, with regard to medical records of a person with mental illness, Mental Health Care Act of 2017, Section 25 plays a crucial role here. And also, this access to basic medical record can be taken and accessed only by persons with mental illness, not even from their legal guardian or else by the family members. Please remember this. If a person with mental illness wants his basic medical record, he need to apply in Form A. This Form A is available in the Central Mental Health Rules. What are those rules? That is Mental Health Care Rules 2018, that is Rights of Persons with Mental Illness, Form A and B. These are the rules forms which are available at the end of the rules. They are also considered as basic medical records, applying for rules and also issuing rules format Form B. Let's look into this Mental Health Care Rules 2018. This is the Form A. In this Form A, patient need to apply to the medical officer in charge of the establishment to release this information. When this basic medical records has to be given, along with the application, the patient need to provide his details, his identity, mental health establishment ID, that is patient's ID or UHID, should be provided to the to be provided to the psychiatrist, who will in turn give this information. This is the Form A under which the patient need to apply for getting basic medical record. What are these basic medical records? The basic medical records have been divided into various categories, such as outpatient records, inpatient records, psychological assessment, and psychotherapy session notes. Outpatient records looks like this under Form B. These are the simple format where A to G forms the basic medical record for outpatient. And again, this outpatient record need to be kept with the psychiatrist or the psychotherapist. This record should be made accessible to the patient whenever he requests. For inpatient basic medical records, in inpatient basic medical records, A to T are the important information which should be made available to the patient as a basic medical record. Why I am discussing this? Invariably, psychotherapy is done both in outpatient and also inpatient. The patient has right to access these both outpatient records and inpatient records. Now coming to psychological assessment. Again here, Form B. Under this, the psychological report has to be given. This is how the psychological report looks like. Here it is very clear. It has been divided into various categories. Let's discuss each one of them. First and the foremost is clinical records and demographic details of the patient. Second one is reason for referral. What is the assessment you are doing? Either IQ assessment, SLD assessment, neuropsych assessment, personality assessment, or psychopathology assessment. Moving further, any other information which you want to capture here. Any brief referral purposes, notes, and also if it is referred from the court will be documented here. Brief background information. Who are the informant? What are the silent observation during the psychological assessment report will be documented here. And finally, what are the tests and scales administered? Silent scores. What is your impression? Recommendation. And finally, who did the assessment? And if the assessment is supervised by the therapist, need to be documented here. So my dear friend, this is the format in which you are going to give to the patient, and these are all basic medical record, and the patient has right to access this basic medical record. Moving to the psychotherapy session notes. Again under form B, this is how psychotherapy session notes need to be documented, and for every session you are going to document, either it is in person or online, and you need to provide these session notes to the patient, and they are part of the basic medical record. Let's go through detail about this therapy session notes. First one is patient's demographic details. Second one is session, number of session, when was the session started, objective of this session, who are the participants of this session, whether it was a group therapy, any other format appeared here. Key issues discussed, it may be psychosocial stressor, interpersonal problems, cyclic conflict, crisis, behavioral difficulties, emotional difficulties will be documented. Therapy technique used, therapist observation and reflections will be documented. Finally, the plan of next session, date of next session will be discussed here, and the signature of the therapist or the supervisor will be documented here. Please remember, professional privilege and confidentiality. Is there a legal immunity? Of course. Right to basic medical records under section 25 has placed certain immunities. Suppose the patient is violent and he is clearly telling that he is going to harm somebody. Under that circumstances, should you keep confidentiality? No. Confidentiality is not absolute. And also at the same time, whenever you are going to provide basic medical record, and if the person, if you feel that he is going to be harmed by complete disclosure of medical records, in such a scenario, the medical officer in charge of the establishment will provide only the basic medical records, and you will inform the patient that certain information and the complete records are not given. He can apply to the mental health review board, and the mental health review board can give order for the release of such information. And the mental health review board, when they order, they need to understand whether complete disclosure is required or not, and why the psychiatrist is refusing to give, and what are his concerns. Further, these medical records can be accessed by the state authority, central authority, mental health review board, high court and supreme court. Whenever you release the information to the legal authorities, please do take consent from the patient. If the patient refuses to give consent, inform to the court and ask the court to issue an order to release the documents. That means you are disclosing the information to the court on the orders of the court, so that tomorrow you will not be held for violation of confidentiality, and the confidentiality was broken on the order of the court. Let's discuss the tips of psychotherapy documentation. Please remember, there are mandatory recording which has to be done. Please do those mandatory recording and documentation, such as keeping session notes, psychological assessment notes, and also progress notes. All release of these documents should be done as per Mental Health Care Act of 2017 or else as per the local laws. Avoid recording fantasies, third-party information, unrelated information in the patient's medical record. You need to have a clear policies, how these records are kept, when these records are stored, how long it is stored, how it is disposed, and if there are legal issues, how it will be disclosed to the court. These policies need to be recorded and kept in black and white, so that whenever the patient or the court requests this, that needs to be provided. To conclude, my dear friends, psychotherapy notes are very, very sensitive information, and confidentiality of these records is very prime, and they are protected under the statute. Only the person with mental illness can access these records under Section 25 of Mental Health Care Act of 2017, right to basic medical records. Therapist has a responsibility of documenting, recording, securing, storing, retrieving, and disposal of these records. Mental Health Care Rules 2018 dictates the format of recording in Form B. Persons with mental illness have right to basic medical records. At the same time, they have right to confidentiality also. Please remember, right to confidentiality is not absolute. There are certain exceptions have been placed under Mental Health Care Act of 2017. Thank you very much for your valuable time. Stay safe.